for their representation. So there will be frequent visits to ensure that this one keeps going on. Catholic Justice and Peace, since 1994 we've had cases and we have been running cases, and most recently even this year we've run cases. Some of the cases we have successfully gone through just because maybe during the engagement we had the basic ingredients. For example, if it's a gender-based violence case, we had the P3 form filled in time, we had the witnesses coming and recording their statements well, and that there has been total cooperation between the police and the court in ensuring that that case goes on very well. But we have also met some challenges, and most of our cases have actually defaulted, and some of our people have actually gone into prison because of lack of witnesses. Another challenge is that maybe during the contraction time there was a problem with documentation in terms of evidence adduced in court, like there wasn't the P3 form, or that the family at some point wanted to compromise with the culprit, therefore making it very difficult for the complainant's family to come and actually to testify in court. So we've realized that it is because of lack of awareness on the criminal procedure that we have really fallen apart, and it has been a great challenge to us as a program, because in some cases we actually hire advocates, and we expect that once a lot of money has been spent in the program, you expect that something good is coming, but only to find out that you have been let down. But we are not losing hope, because we have realized that the demand of many of our clients at the moment is being met at that local level, whereby we have trained the paralegals and trained the chief to arbitrate on the smaller cases that will have been expensive if brought to the offices and actually be brought to court and those other offices.
Legal Resources Foundation is a human rights organization that is Kenyan based, and we operate with one main objective. This is access to justice for the poor, marginalized and the vulnerable in our communities. We have got different programs that we endeavor to contribute to this particular aim that we have. These include the access to justice program, whereby we are looking at how do we enhance the efficiency of the different institutions within the justice system. And that is the judiciary. We are looking into judicial reforms. We are also looking into penal reforms. We are also looking into police reforms, and also reforms within the probation department and other departments that are related. In particular, one of the main aims that you find this particular whole week we have been in Turkana, and more specifically Lodwar, is that the community around here, out of an assessment we conducted, is that access to justice is still parable to them. They do not have a definition for it, because one, the court system, for example, we have only 2 courts sitting in Lodwar, and we have litigants, if they are there, traveling over 360 kilometers to seek the formal justice system. This hasn't worked for them very well. Of course, you can see the climate here is not conducive. It's going up to even sometimes up to 42 degrees centigrade. So one of the things that we started over a period of time to ensure that the vulnerable people here, the marginalized people here can access justice, is a pilot of small claims court. And somebody will ask, what is small claims court? The small claims court came into inception by virtue of seeing that our courts are, there is a big backlog of cases that has been caused by the congestion of so many cases that are coming in and still not being finalized in the judicial system. The small claims courts are courts that have been modeled to deal with small matters of civil nature within the community setup. And these particular courts, we have, for example, in Turkana, we have 3 of them that are sitting. One of them being very efficient, that is in a place called Kataboy location. We have seen that the elders sit down together and they determine matters. And this, we have seen a very good working relationship between the provincial administration and the community, in that there is no magistrate, an advocate, who sits in to preside over matters, but it is the provincial administrator, that is the chief or the assistant chief, together with a recognized elder. These particular courts hear cases of, for example, you owe me 500 shillings, you never paid it up in good time as required. As such, you find that people would run to the formal court system, which is one very expensive for them because they are filing fee in court. The civil procedure is very expensive, which means then I have to hire an advocate. How many Kenyans would afford to hire an advocate? Then the period of getting justice within our formal system, considering the backlog that is there on the congestion, is quite a long period. You'll find a civil matter, regardless whether it's a small case or a big case, would take between, on average, between 6 months and 6 years. And you have seen others that have even gone for 20 years. But the small claims courts are courts that have been modeled in a way that, one, between the time the complaint has been registered, within the first and the second sitting, which would happen within a month, the case has been determined. Number two, the formal court system, which has been seen to be not friendly to the people in the language that it uses. One, English, not everybody knows English. Number two, the technical language that advocates speak is not being seen at the small claims court. The small claims court use local language. If it's here, they would use Turkana. If it's in Kambaland, it would use Kamba. If in Kikuyu land, they would use Kikuyu. And number two, the technical lawyer's language is not present. The good advantage again of the small claims court is a court that is based at the location level. Whereas the formal court system would find it is based in urban settings, which is far from the people. So people will be able to commute easily, and you will not see cases being adjourned frequently by basis of the complainant could not appear or the accused person could not make it on time because it is at the place. Then the other fourth advantage of the small claims court is the fact that the small claims court have a restorative nature of resolving disputes, and that you are my neighbor. It's either a win-win situation or a way that the case will be resolved is in a way that will never have grudge between us. Unlike the formal justice system, whereby if you take me to prison, my kids will hate you forever because you took their sole breadwinner out of their system. So those are the kind of things that we are looking at in terms of what we need to do. And my call in this is that the government of Kenya has got a huge responsibility. One is to see how do we ensure that our formal justice system works efficiently. And a historical problem has been the issue of congestion and in the courts, which has caused the backlog. For us, this particular congestion can be dealt in one way, establishing two courts. One, courts of petty sessions. These are courts that will deal with criminal matters of petty nature. For example, gambling, drunken disorderly, board to keep peace. And then also establishing the second court, which is small claims court, which I've spoken about. In that, the formal justice system has had the congestion because 60% of the cases actually which are in the system are of small or petty nature. Then secondly, there has been a whole argument that the judicial officers are not enough. For us, that does not withstand, because a case study is Uganda has got an average of, as per January this year, 84,000 pending cases in court. Yeah. Now,